Good morning, Sir Michael.
Good morning, Sir Brian.
You can hear me, good, that's a start. Can you see me?
Yes, I can hear you. I can see you.
Good.
Yes.
In a moment or two, you will be asked questions by Ms. Richards. Let me just describe the scene here for you so you know who you're talking to. There is a small audience here in in Aldwych House. There are a number of legal representatives of different interested participants. But you're talking really to people beyond this room, those who are watching on YouTube or on live stream around the country, probably around 100 or so there. So that's your audience. We will take breaks whenever you need them, but otherwise, generally, the first break will be around about 11:15. Ms. Richards, once you have been sworn, we'll begin the evidence. Mary.
Please state your full name.
Michael David Rawlins.
And repeat after me. I do solemnly, sincerely.
I do solemnly, sincerely.
And truly declare and affirm.
And truly declare and what?
Affirm.
Affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Sir Michael, can you see and hear me?
I can indeed.
Good. Just before we start, sir, for the benefit of the wider audience, I've been asked a lot of questions, or had suggested to me a lot of questions for Sir Michael because of the interest in licensing and regulation. And I just wanted to take the opportunity to remind call participants and legal representatives that we do have two other statements that may assist in answering some of those questions. We have a written statement from Dr. Duncan Thomas, the reference for which is WITN 6405001, and that is both available to legal representatives and published on the Inquirer's website. We also have a statement from Sir Joseph Smith at WITN 5281001. That has been disclosed to legal representatives and court participants, but isn't yet published on the Inquirer's website. We are also in the process of obtaining a statement from Dr. Trevor Barrowcliffe, who will also, we think, be able to assist in understanding, in particular, the work of NIBSC. I mention that now because some of the questions I've been asked to ask Sir Michael are answered, or maybe more likely to be answered, in those other statements. Sir Michael, I want to start with an overview of your career and pick that up from your witness statement. Paul, could we have WITN 6406001, please? And if we go to page 7. So we can see there, Sir Michael, that you graduated in the course of the 1960s, and by 1968 you were a member of the Royal College of Physicians of London. Is that right?
That's correct. I passed their exam, yes.
And then, in terms of your employment history, between 1966, that's at the bottom of the page, and if we go over to the next page, and 1970, you had various clinical posts as a house surgeon, house officer, or senior house officer, or lecturer in medicine. Is that right?
That's correct, yes.
Did any of your clinical work involve the treatment of patients with haemophilia or other bleeding disorders?
No.
Do you recall whether during your medical training or the clinical roles that you've described there, whether you received any training or education more generally on the use of blood for transfusion?
Well, I'm sure I was taught about giving blood transfusions, but not haemophilia.
Now, we can see then, from 1970 onwards, you began to specialise in the discipline of clinical pharmacology, becoming a professor of clinical pharmacology in 1973 and an honorary consultant in 1977. Can you assist us with what is the discipline of clinical pharmacology?
Clinical pharmacology is concerned with the study of medicines generally, not devices, but medicines. How they work, why they work, whether they work, what side effects and adverse reactions they produce, that sort of thing.
And was there any particular area, specialist area of clinical pharmacology that you focused on, or was your expertise general in nature?
Well, it was general because I did a lot of teaching of medical students in Newcastle. But I was particularly interested. It sort of started off when I was a lecturer at St Thomas's. I became interested in how aspirin works, how it lowers temperature when you have a fever, how it reduces pain and that sort of thing. So I did quite a lot of work on aspirin, but many other things as well.
And then if we look at the bottom half of the page, we can see a number of the positions you held. In 1979, you became a member of the Committee on the Safety of Medicines, and you remained part of the Committee on the Safety of Medicines until 1998, rising to become Vice Chair in 1987 and then Chair in 1993. Is that correct?
In 1979, I became a member of a subcommittee of the CSM. Not the CSM itself. It wasn't until 1980 when I became a member of the CSM itself.
And then in terms of the subcommittees, we can see your involvement with 3 subcommittees. The Toxicity and Clinical Trials Subcommittee to start with, and
Yes,
then you became a member of
that was subsumed into SEER, Safety, Efficacy and Adverse Reaction Subcommittee in 1980. There was a reorganisation of the subcommittee structure.
And then I think the Safety, Efficacy and Adverse Reaction SEER Subcommittee. You also refer there to the Adverse Reaction Group of SEER, Argos. Was that a subcommittee of the subcommittee, so to speak?
That's right, yes.
And
yes,
then we'll obviously...
just a small number of us from SEER were on Argos. We were known as the Argonauts.
And we'll come back, obviously, and look at that in more detail. If we then go to the top of the next page... we can see some other positions you've held, and I just wanted to flag up 2 of those. Between 1999 and 2013, you were chair of the National Institute for Clinical Excellence, and then between
I was the founding chair.
And I'll ask you a little about that at a later stage of your evidence. And then between 2015 and 2020, you were chair of the Medicines and Healthcare Products Regulatory Agency, the MHRA.
That's correct.
We can take that down, thank you, Paul. I wanted to just ask you, before we look at the work of the CSM in more detail, a little about the concept of pharmacovigilance. Can you tell us what that is?
Well, pharmacovigilance is a sort of sub-discipline of clinical pharmacology, looking at what happens to medicines during their routine use in patients, in the population.
And would it be right to understand that pharmacovigilance embraces both licensing, the consideration of whether products should be available, medicines should be available to the public, but also the ongoing monitoring of the safety of medicines throughout their use in healthcare practice?
Really more concerned with the ongoing evidence of safety and efficacy.
And I'll want to ask you some more about those concepts of safety and efficacy in due course. Can I then ask you a little about your membership of the Committee on the Safety of Medicines and its subcommittees? How did you come to join the subcommittees and then the CSM itself?
It was a tap on the shoulder. They weren't advertised. There wasn't an interview. The chairman of the Toxicity and Clinical Trials Committee, I knew a bit, a man called David Graham Smith. who is from Oxford. And one day he gave me a phone call and said, would I join the TCT, as we called it? And then I got, when I got appointed to SEER, again, no interviews, no advertisements, it was just a tap on the shoulder.
As far as you know, was that how most or all of the members of the CSM and its subcommittees came to be appointed?
As far as I'm aware, yes.
Do you know what, if any, steps were taken to try and ensure an appropriate range of expertise and a balance of professional views?
Well, I can only tell you from when I was chairman of the CSM, and I did try and make a balance, get a balance. But when I was chairman, before I asked somebody to join, I had to get the approval of what was by then the Medicines Control Agency, who I think also sometimes asked ministers or sought advice from ministers.
And do you know what, if any, conflict of interest checks were undertaken in relation to potential members of the CSM or its subcommittees?
I'm not sure whether they were really taken into account. Quite clearly, there was potential for members of the CSM and its subcommittees to have conflicts of interest. And I think they were expected to declare them, but I don't think there was a strict rule about it.
Now, we'll look at a document shortly which gives a description of the various subcommittees in the late 1970s. But before we do that, as a matter of generality, was there much sharing of information between or liaison between the different subcommittees, or did they essentially work in silos?
They worked in silos.
And when you joined the CSM for the first time, or joined the first subcommittee, did you receive any training?
No, not at all.
Did that change over the course of the years that you were at the CSM?
Not really, no.
And what proportion of time, of your professional time, did you spend on CSM duties, as far as you can recall?
Well, the main committee met monthly. The subcommittee met monthly. And we got papers for this was long before electronic transmission of documents, and it was all paper-based. And we got papers sent about 10 days or so before each meeting. And they arrived in what was called blue bags. They were, and they usually came in 2 blue bags. Then I used to take them home and read them over the weekend, and then lug them down to London.
Were you and your colleagues remunerated as members of the CSM or its subcommittees?
No, we had expenses paid.
What was the expectation in terms of CSM members keeping up to date with the latest medical and scientific knowledge?
I think it was just an assumption that that's what happened. There wasn't any particular training or anything, no.
And how did you yourself, in particular during the 1980s, keep yourself abreast of evolving understanding about medicines and their safety and efficacy?
Well, I was a clinical pharmacologist, so it was sort of part of my daily work to keep abreast of not just the things I was interested in from a research point of view, but more broadly, because I was teaching junior staff, I was teaching medical students, I was teaching dental students too sometimes. So I had to keep abreast.
In terms of your other colleagues, in particular on the main committee on the safety of medicines, were they also clinical pharmacologists by background, or was there a range of different disciplines?
There was a range of them. I mean, there was a neurologist, there was 2 pharmacists, as far as I recall. There was a range of people.
were you familiar with, or did you read a publication known as MMWR, Morbidity and Mortality Weekly, during the 80s?
No, I don't recall that at all, no.
And I think it's right to make clear, you were not a member of the biological subcommittee of the Committee on the Safety of Medicines.
No.
I'm going to ask you to look with me at a document you've exhibited to your statement, Sir Michael, which gives quite a lot of detail about the licensing system in the late 1970s. Paul, could we have MHRA 0004773? We start on the first page. So we can see this is a document dated July 1977, and it's called The Control of Medicines in the United Kingdom. What I'm going to do, Sir Michael, is read through some of the paragraphs and then ask you some questions about the general
system. A bit larger. Is it possible to make it a bit larger? It's difficult to read. That's it. Thank you.
So if we turn to page 4, we can see what the document is. If we could zoom in the top part of the page. It says, this leaflet's been prepared to provide information on the control of medicines in the UK. It describes the legislation used to exercise control and the work of the Medicines Division of the Department of Health and Social Security in implementing and administering this legislation. It begins by outlining the history of drug control and goes on to discuss the organisation of the regulatory authorities. And then, if we go further down the page, please, Paul, there's a heading, the history of control. And if we can go to paragraph 4, please, if we could just zoom in on that. We can see there, and this is just by way of establishing the history, Sir Michael, paragraph 4 explains that at an earlier stage, except in relation to biological substances and dangerous, e.g. narcotic drugs, no limitation was placed on the freedom of an individual manufacturer to put a new medicinal product on the market. Most of the established manufacturers did in fact carry out thorough tests and trials, but were not obliged by statute to do this. The need for further legislation was already being considered when in November 1961, the revelation of the effects of thalidomide called public attention to the inadequacy of existing measures. And then this goes on to describe the establishment, first of all, of a committee on the safety of drugs. And then if we go to the top of the next page, the first paragraph, we can see, picking up in the second line, that there was a recommendation that there should be new legislation giving statutory backing to the committee's advice and comprehensively overhauling all legislation relating to medicines. And in due course, then, there was the Medicines Act, receiving royal assent in October 1968. Paragraph 6 then describes the Medicines Act as a comprehensive measure replacing most of the previous legislation on the control of medicines for human and veterinary use. The Act is administered by the Health and Agriculture Ministers of the UK. In some circumstances, they act together, but they can act separately. And then paragraph 7 explains that the health ministers consist of the Secretary of State for Social Security, the Secretary of State for Scotland, the Secretary of State for Wales, and the head of the Department of Health and Social Services for Northern Ireland. And then it goes on to identify the agriculture ministers. Just pausing there, so Michael, did you yourself, when you were involved with the CSM as a member, have any direct dealings with the health ministers?
No. All the dealings were with the Secretariat of what was then the Medicines Division.
And then, if we go further down the page to paragraph 8, please, Paul, we can see there the basic structure that the Act established. including at paragraph 8b, committees with specific advisory functions, and C refers to a licensing system being established which regulates the marketing, importation, manufacture and distribution of medicinal products. It's operated by the ministers acting as the licensing authority, which is advised by appropriate committees. If we then go over the page, please, Paul, to page 7. Sorry, not over the page. Go on to page 7. I just want to pick it up at paragraph 14 and 15, Sir Michael. So paragraph 14, if we just zoom in, refers to the Committee on the Safety of Medicines. This committee is in effect a continuation of the former Committee on Safety of Drugs, and it advises the licensing authority on questions of the safety, quality and efficacy of new medicines for human use. It is also responsible for collecting and investigating reports on adverse reactions to medicines already on the market, and it may issue warnings about newly identified hazards or, where it seems appropriate, reminders about those already recognised. The committee has at present 19 members made up of a broad cross-section of medical and pharmaceutical disciplines. Now, just pausing there, Sir Michael, paragraph 14 describes 3 broad areas of activity for the Committee on the Safety of Medicines. The first is the advice to the licensing authority on questions of safety, quality and efficacy. In practice, that's considering licence applications, is it, and advising whether they should be granted, and if so, on what conditions?
Yes, and also whether licenses should be withdrawn, revoked.
And then the second broad area of activity is what's described there as the responsibility for collecting and investigating reports on adverse reactions. And that was very much the focus of the subcommittee of which you were a member, Sir Michael, is that right?
Yes, these were the yellow card reports.
Yes, and I'll be asking you about that in more detail later on this morning. And then there is also then reference as a third area of activity, perhaps related to the investigation of adverse reactions, the issuing of warnings about newly identified hazards or reminders of hazards that were already recognised. So is it right to understand that the CSM had a role in promulgating information about the hazards of medicines?
That is correct, yes, although, yes, that's right. Now, we had this little magazine thing called Current Problems. I think you have seen copies of them. And when things were very bad, the chairman of the CSM wrote a Dear Doctor letter to all doctors.
Yes, and we'll look at some examples of that in due course. Then paragraph 15 refers to the subcommittees. Now, at that point in time, 1977, 6 subcommittees. The first was the Toxicity, Clinical Trials and Therapeutic Efficacy. The second was Chemistry, Pharmacy and Standards. The third, Biologicals, which dealt with blood products, amongst others. The fourth, Standards of Herbal Products. Fifth, Adverse Drug Reactions. And then sixth, Antimicrobial Substances. Now, you've told us in your statement how the organisation of the subcommittees changed over time, and I'm not going to go through the detail of that, but I think it's right to understand that there was always a subcommittee dealing with biologicals, and there was always a subcommittee dealing with adverse reactions. Is that correct?
Yes, that is, yes. Yes, but in 1980, the adverse reactions became part of SEER, Safety, Efficacy and Adverse Reactions.
And then if we go over the page to page 8, please, Paul. We can just pick it up at paragraph 19 under the heading Reports. We can see it says the Medicines Commission and the expert committees each make annual reports to the ministers. These, together with a memorandum from the Medicines Division of the Department of Health on the work of administering the Medicines Act, are laid before Parliament. Is this right, that the committees would produce annual reports Again, we have a couple of examples in the papers summarising the work of the committee during that year.
That's roughly right, yes. I mean, well, sorry, not roughly right. That's correct.
And then if we pick it up towards the bottom of the page, just above paragraphs 22 and 23, so we've got a heading there, the Medicines Division of the Department of Health and Social Security. Paragraph 22 explains that the functions of the health ministers of the United Kingdom under the Medicines Act are discharged on their behalf by the Medicines Division of the Department of Health and Social Security in London. Paragraph 23, the division includes medical, dental, pharmaceutical, legal, administrative and clerical staff. The various professions work closely together, both in relation to particular projects and areas of interest, and in relation to the development of general policies. The work of the division is coordinated by its senior staff, meeting as the divisional, top of the next page, management group. And then we can pick it up at paragraph 24. At the end of 1976, the full-time staff of the Medicines Division was 232, of whom 18 were doctors, 51 pharmacists, 19 were scientists and other disciplines, 19 were senior administrative and executive staff. The 19 scientists were members of the Secretariat, the Medicines Inspectorate, and the laboratory of the BP Commission. Is that the British Pharmacopoeia Commission, BP?
Yes, yes.
The pharmacists, 18 were medicines inspectors. In addition, 4 lawyers were engaged full-time in work relating to the Medicines Act. And then we have a description of the main functions of the Medicines Division in paragraph 25. And we can see it says, as licensing authority, 1, Medicines Division is involved at every stage of the licensing of medicinal products. New applications for product licenses and clinical trial certificates are assessed jointly by a doctor and a pharmacist. A summary of the evaluation is submitted to the appropriate Section 4 committee to assist members to formulate their advice to the licensing authority. The division provides both the professional and the administrative secretariat of these committees. And then paragraph 2 deals with manufacturers and wholesale dealers' licenses. Those are evaluated by the Medicines Division on the basis of information supplied by the Medicines Inspectorate. And then point 3, the division ensures that all the applications comply with the relevant regulations and provisions of the Act. And then we can see the next heading is as enforcement authority. So the Medicines Division is responsible for ensuring the enforcement of the Act. And then we have the reference to adverse reactions monitoring, subparagraph 5. The division provides staff who work under the direction of the Committee on Safety of Medicines and its Adverse Reactions Subcommittee in particular to monitor adverse reactions to medicinal products. 4 doctors are engaged on this work full-time, assisted by 80 part-time doctors distributed around the country who follow up selected reports and can undertake special inquiries. So just pausing there, I wanted to give what I understand to be a rough outline of the licensing process and see if this accords with your understanding, Sir Michael. The licensing application would be considered in the first instance by the Medicines Division of the Department of Health and Social Security. Is that right?
That's correct. That's correct. That's right, yes.
And there'd be an assessment by a pharmacist and by a doctor who worked for the Medicines Division, and they'd produce reports.
Yes, it would also include a toxicologist to look at the animal studies and to find out whether anything had happened to the animals, whether it occurred in humans or whether it had been monitored. So it would be a toxicologist as well as a pharmacist as well as a medic.
And then those reports would be submitted to, or could be submitted to the relevant subcommittee. So in relation to blood products, which is obviously the inquiry's focus, they'd be submitted to the biological subcommittee, which would consider the reports and formulate a recommendation. Is that broadly accurate?
That would be correct, yes. I should also emphasise that the reports from the Medicines Division staff didn't just summarise the data, but the Medicines Division staff had its own views on it, and would say, the evidence for this is inadequate, or the evidence is very good or convincing or whatever. So it wasn't just a summary of the original application. It would also include their views and their opinions.
And then, as far as you can recall, did all applications for product licences get referred by the Medicines Division to the appropriate subcommittee? Or were there occasions when the Medicines Division staff themselves would take a decision without seeking advice from the subcommittee?
No, I think, as I recall, under the Medicines Act, they all had to be considered by the Committee on Safety of Medicines.
And then, once the subcommittee had considered these reports and formulated their own recommendations, were those always considered by the main committee, as far as you can recall?
Yes, as far as I can recall, yes, the subcommittee would report to the main committee, and then the main committee would then send its advice to the Medicines Division.
And so, in a sense, there was a degree of circularity in the process, because the committee's advice would go back to the Medicines Division, and it was the Medicines Division which actually exercised the Minister's licensing functions under the Act.
Yes.
Do you recall whether the committee's advice was ever rejected by the Medicines Division?
Not that I recall. No, not that I can recall. But then, I think that if the medicines, if the CSM or other advisory committees was going to produce something that the Medicines Division didn't agree with, I think the Medicines Division staff would tell the committee that they didn't agree.
And if we just go over to page 11 of this document, please. I'm not proposing to ask you about this, Sir Michael, but I just flag it up. It gives the organisation of the Medicines Division, at least as at 1977, with the number of medical officers who were concerned with adverse reactions, the number concerned with biological products, and so on.
Yes.
If we can go then to page 12, we have a heading there which is licensing of medicinal products near the top of the page. I'm not going to go through the detail of what's set out there, but I just wanted to look at paragraph 32 on page 13, please, Paul. We just zoom in on paragraph 32. So this describes the licensing process. Applications for product licences and clinical trial certificates, other than licences or certificates of right, are usually referred to the appropriate committee for advice on their safety, quality and efficacy. Members receive summaries and assessment from the professional staff of Medicines Division and the expert subcommittees, and then formulate their advice to the licensing authority. And then it refers to the system in relation to manufacturers' licences, and then in the last sentence, wholesale dealers' licences. And then if we look, please, Paul, at paragraph 34, bottom of the page, we have a section headed Refusal of Applications for Licences, Suspension, Revocation and Variation of Existing Licences. If a Section 4 committee has reason to think that it may be unable to advise the licensing authority to issue a clinical trial certificate or grant a product licence, or has it in mind to advise that an existing licence or certificate be revoked, varied or suspended, the applicant or licence/certificate holder must be given the opportunity of appearing before it or making written representations to it. If, after considering the representations, the committee advise against granting licence, the licensing authority has to inform the applicant, who may then make representations to the Medicines Commission at a further hearing or in writing. The Act also provides for further appeal procedures in special cases. Now, I'm not going to go through the details of the appeal procedures with you, Sir Michael, but is this right, again, in broad terms? When the committee or the subcommittees were considering the applications for product licences, they considered their meetings, but they didn't hold hearings at which the pharmaceutical company would be represented unless they were minded to refuse the licence or revoke it or vary it. Is that broadly right?
That's correct, I think, yes.
And then, as we see set out there and elsewhere, there were various appeal mechanisms if the ultimate advice was to refuse or revoke the licence. If we then, Paul, could go to a separate document, please. It's WITN 6406003. Now, this is an annual report of the CSM for 1990. If we just zoom in on the top half of the page to start with, thank you. So we can see the terms of reference for the Committee on the Safety of Medicines there set out in paragraph 1, to give advice with respect to safety, quality and efficacy in relation to human use of any substance or article to which any provision of the Medicines Act 1968 is applicable. And then secondly, to promote the collection and investigation of information relating to adverse reactions for the purpose of enabling such advice to be given. And then if we look at paragraph 3, meetings, the report from 1990, Sir Michael says the committee held 11 meetings during 1990. 2-day meetings were held in February and July to enable the committee to complete its business. Would it be right to understand from that that the rest of the meetings ordinarily were 1-day meetings?
That's correct, yes.
And then there is data on the consideration of applications, which we can see if we go over the page. I'm not proposing to go through the detail of it, but the table A refers to consideration of applications for product licenses, and then table B refers to advice following hearings and written representations. If we can go to the third page, please. Could we just zoom in on paragraphs 4.5 to 4.7, Paul? Can you make those a bit bigger? Thank you. So we can see that in 1990 it said the committee considered on average 21 applications per meeting compared to 16 per meeting in 1989. Was that generally the kind of numbers that would be considered at the CSM's meetings?
Yes, I think so.
And then 4.6 refers to the committee giving advice to the licensing committee and CPMP on a number of variations. And then 4.7 says this: during the year, the committee continued its policy of writing to chief executives of pharmaceutical companies to commend particularly good applications and express dissatisfaction with particularly bad ones. 6 letters were sent, of which 4 were complimentary. Other comments about the quality of applications are regularly conveyed to companies by the committee's secretariat. Can you recall anything about why that policy was adopted and what it was designed to achieve?
No, I can't, I'm afraid. Sorry.
Right. And then, if we look at paragraph 5, under the heading Consideration of Other Matters, it said, in addition to applications and appeals, the committee also considered and commented on papers of medical and pharmaceutical interest. The total number of such papers considered in 1990 was 88, of which 41 dealt with adverse reactions associated with medicinal products, 7 dealt with CPMP matters, and the remainder were general information items. Now, that would suggest that the CSM in its meetings, as well as dealing with the actual applications or appeals before it, would also more broadly consider developments relating to adverse reactions or broader developments relating to medical and pharmaceutical matters. Is that correct?
That's correct, yes, particularly adverse reactions.
And then if we can go just to the next page. the second paragraph, paragraph 6, safety of marketed products. This explains that newly introduced products denoted by a black triangle symbol in data sheets BNF, MIMS and advertisements are under intensive surveillance by the committee. Can you just assist us with what the black triangle scheme was and what was meant by intensive surveillance?
Well, it was a sort of reminder, really, if you like, for doctors to report suspected adverse reactions. It was a sort of, and not to be selective about the ones they report.
We'll pick up on some of the concerns about adverse reaction reporting a little later. Do you recall whether the Committee on the Safety of Medicines had any broad jurisdiction in relation to the promotion of public health more generally?
Not really, no. It was concerned with medicines.
And then, can I then just ask you about the CRM? So I think that was the Committee for the Review of Medicines.
That's right.
What was that? Did that operate as a completely separate body to the CSM?
Yes, it does. It did. It was set up because when the Medicines Act came into force, there was hundreds of medicines that were already on the market. And it was the job of the Committee on Review of Medicines to see whether their marketing authorization, their licenses were appropriate. Because when the Medicines Act started, all medicines already on the market were granted product licenses of right, PLR, and it was the Committee on Review of Medicines had to go through all the PLRs to see whether they were appropriate to be continued on the market.
And was there any sharing of information between the CRM and the CSM, as far as you can recall?
Well, as far as I recall, occasionally the CRM would consult the CSM about a particular product. But I can't give you any examples, and I don't know how often it happened.
Now, I want to ask you next, again, still dealing with the CSM in fairly general terms, about confidentiality and transparency. The minutes of CSM meetings, and indeed I think of subcommittee meetings, often feature a reminder from the chair of the importance of confidentiality. And I think it's right that members were not permitted to discuss what was happening in the CSM or its subcommittees externally. Is that correct?
That's correct, yes.
And the minute, sorry.
For many years, I don't quite know when, but for many years, the minutes of the CSM weren't allowed to be made available.
Yes, absolutely. So the minutes were not publicly available, nor were they available to clinicians or NHS bodies.
No.
Although they would obviously be available to the medicines division and to members of the Department of Health who attended the meetings.
Yes.
Can we look then at a document which explores that issue about confidentiality? It's WITN 6406007. So we can see this is a document from June 1998, so towards the end of your chairmanship of the CSM, I think, Freedom of Information and the Committee on the Safety of Medicines. And if we go over the page, just have a look at the executive summary. If we can look at the top half of the page first of all. It says the CSM welcomes the opportunity provided by the government's Freedom of Information white paper to be more transparent about its activities. It regards the present constraints preventing disclosure placed upon it by both statute as well as by custom and practice as being against the broadest public interest. The CSM believes that its overall objective, subject to certain exemptions, should be the disclosure to the professions and to the public of both its advice and the reasons for its advice to the licensing authority. The CSM recognises that certain categories of information require to be exempt indefinitely from disclosure. These include matters relating to national security, law enforcement, personal privacy and certain commercial interests. And then 4, the CSM believes that 2 categories of information require to be exempt from disclosure for a limited period, 42 days are proposed. These include share price sensitive information and policy advice to ministers. And then if we look at paragraph 6, it says the committee does not believe that holding its meetings in public in whole or in part is either desirable or practicable. It would, though, wish to hold an annual public meeting to allow the media and the public to learn more of its activities and to give the committee the opportunity to hear of others' comments and concerns. Paragraph 7, the committee proposes that its minutes be disclosed 42 calendar days after each meeting. This would enable the simultaneous disclosure of its advice and the reasons for its advice on matters about which it does not wish to seek exemption and those for which it seeks temporary exemption. 8, the committee's minutes do not provide the reasons for its advice in a manner that would be useful to prescribers, consumers or healthcare purchasers. It therefore proposes to prepare and disclose for each successful marketing authorisation application a document that would summarise the data upon which the committee based its advice with explanations as to the reasons for judgment on quality, safety and efficacy. And then if we go on to page 4, there is then more detail set out about both the background and the recommendations summarised in the executive summary. If we just go to page 7, before I ask you about this. So paragraph 6, halfway down the page, principles of disclosure. The committee is concerned about the extent to which its proceedings and advice are undisclosed to health professionals and the public. It believes that the government's white paper, Your Right to Know Freedom of Information, offers it the opportunity to fulfil 2 objectives, and then those are set out, including at 6.2, the committee believes that disclosure of the reasons underpinning its advice, particularly in respect of marketing authorisations for new active substances and significant safety issues with medicines already marketed, would have public health benefits. It would provide prescribers with a better account of a product's efficacy and indications. It would enable them to understand more fully the reasons underlying specific dosage instructions, contraindications and warnings. It would enable those advising prescribers to offer a better service to their readers and clients. Moreover, it would enable NHS purchasers and providers to make more informed decisions about the availability and use of products within both primary and secondary care. Now, Sir Michael, it would seem from this document that the CSM had been concerned for some time about its inability to disclose more broadly information relating to its decisions. Is that right?
Yes, I think that's right, yes.
And this document suggests that the CSM seized upon the opportunity offered by a white paper on freedom of information to argue for it to be permitted to make disclosure along the lines described here. Do you know why had the CSM not pressed for this at an earlier stage? Do you know?
Well, I can't really answer that question. It was sort of just assumed that we couldn't. And I remember being once we were subjected to the Secret Act.
you left the CSM, I think, at the end of 1998. Do you
That's
know
right.
whether these proposals were put into effect?
I don't know.
Well, I'm sure we can ascertain that from other sources.
Yes.
Um,
What I do know is that when I went to NICE and set up NICE, we were much more transparent than we'd ever been at the CSM. It was a sort of lesson I took forward.
Now, I just want to ask you now a little more about the process of consideration of licensing applications. I think we can do it by looking at a document at CBLA 0000272. This, in fact, is a letter from the Medicines Division to the Lister Institute, May 1975, talking about a manufacturer's license. But if we go over the page, what we get is some information about how to apply for a product license. I'm not going to go through this paragraph by paragraph, but if we could go to the bottom of the next page, please, Paul. We can look at paragraph 2.6 towards the bottom of the page. So you'll see there, Sir Michael, it says contraindications, warnings and precautions. State particulars of contraindications, warnings and precautions to be included in the data sheet, container label, package label or any leaflets. So first of all, is it right to understand from this, Sir Michael, that those applying for product licenses were expected to set out in their application information about contraindications, warnings and precautions, and to identify the information that they propose to include in data sheets, leaflets and labels and so on?
That's correct.
How, to what extent was that scrutinised by the subcommittees or the Committee on the Safety of Medicines?
Well, I think it was really scrutinised by the staff of the Medicines Division.
And do you recall whether there was any particular guidance or advice or criteria about what should be included or the kind of terms in which warnings should be expressed?
I'm afraid I don't know.
Do you... sorry, if we go over the page, first of all. So there's a heading there, Supplementary Particulars, and then there sets out, again, a range of information which had to accompany the application for a product licence. We just go towards the bottom of the page, scientific evidence, the last paragraph. It says this form should be accompanied by detailed information on chemistry and pharmacy, experimental and biological studies and clinical trials as appropriate. Now, the inquiry has seen some examples of the kind of material that might accompany product licence applications. Would that data be scrutinised by the subcommittees and the CSM itself, or would the subcommittees and the CSM rely upon the Medicines Division staff to go through the detail of this range of scientific evidence?
I would expect the Medicines Division staff to do that. If the Medicines Division staff had concerns, they might well inform the relevant subcommittee or relevant committee, but it was mainly the Medicines Division staff.
And do you recall whether either the Medicines Division or the subcommittees or the CSM, whether they would ever seek outside expert advice in relation to product licence applications, or whether it was always considered only by Medicines Division staff and then the committee and subcommittee members?
No, I don't recall us going outside.
Do you know whether there was any prohibition on seeking external advice?
Not that I'm aware of, except for the whole problems of confidentiality.
And then we saw from the 1990 annual report that that the CSM would often be considering a number of applications at its meetings. To what extent was the CSM performing a rubber stamping exercise?
Yes and no. When it came to some of the advice from subcommittees, the CSM would tend to accept the advice, or as you want to put it, rubber stamp the advice. For example, the advice from the Chemistry and Pharmacy subcommittee, as far as I recall, there were only one or two chemists and pharmacists on the main committee, so that we were heavily dependent on the views and the wisdom of the relevant subcommittee.
Can I turn then to ask you a little about the criteria against which licensing applications, product licensing applications were assessed? So safety, efficacy and quality. Could you just set out in broad terms your understanding of each of those and what the CSM was looking at?
Quality refers to whether the pill or the injection or whatever it is has got the what it said it's got on it, and that it's in a pure form, and that the excipients, when you have 5 milligrams of aspirin or something, there's lots of other bits, other chemicals there to bulk it up a bit. So all those had to be looked at and satisfied on. If it was a slow release preparation, we'd want to make sure that it really was a slow release preparation. And so that was the quality. When it came to efficacy, it was basically did the medicine do what it said it did on the tin? If it relieved headaches, did it relieve headaches? And what was the evidence for that? Safety was partly looking at it in experimental animals. The toxicologists would look at safety in experimental animals, and then if in some animals or some species of animals the product at high doses produced renal damage, kidney damage, had that been adequately monitored in patients receiving it? Added to which, did patients also get, in the trials, also get unwanted effects or effects that weren't anticipated from the toxicologists, rashes and things like that. So that was quality, efficacy and safety. Does that answer your question?
Yes. And then how, particularly focusing on safety, first of all, was there any guidance or criteria in place, whether for the Medicines Division or for the subcommittees or the CSM itself, about the approach to take to the assessment of safety, as far as you can recall?
Well, safety is a sort of balancing act between what is being used to treat and what the adverse effects are. So, if you're treating some lethal condition, then you're prepared to put up with more adverse reactions, perhaps, than something sort of relatively mild. So it was a judgment of balancing safety and efficacy.
If we then look at just some of the other considerations that might form part and parcel of the licensing consideration process, in your witness statement so if we go to WITN 6406001, page 28, paragraphs 711 and 712, licences in other jurisdictions. You say there, Sir Michael, that we would be informed when a licence had been granted in another jurisdiction and would give this some weight, but it would not be a determining factor. We would still carefully scrutinise the application afresh. It would often be helpful to see details of licensing in other jurisdictions, as it could mean that there was more information available about the product's safety and efficacy, as it would have probably been used by more people. And then 712 deals with the particular situation of product licences in other EU member states. You say that that would be given due consideration. In terms of the weight that would be given to licences in other jurisdictions, was more weight attached to licences in certain jurisdictions, such as the United States, if something had gone through FDA approval? Did that carry particular weight?
Well, yes. I mean, it would indicate that a relatively strict licensing body had found it was appropriate. And of course, if a product has already been on the market in the United States, there might be more information on what had happened once it had gone on the market about safety in particular.
And then can I ask you to look, if we're still in the witness statement, at page 31, paragraph 7.21, please. So in fact, just before we look at 7.21, 720 explains that you gave a presentation at the annual meeting between the ABPI and the CSM on the 8th of March 1990, and you exhibited to your witness statement copies of the substance of the presentation. I just wanted to ask you about what you say in paragraph 7.21, so if we can just zoom in on that. You say this, Table 3 shows there were 14 applications rejected on the grounds of safety alone. We observed concerns about clinical safety at initial assessment are perhaps less surprising. Such issues involve risk-benefit decisions that are generally resolved by judgmental analysis. Differences in such risk-benefit assessments between commercial innovators and the CSM are at the heart of drug regulation. So just pausing there, when you refer to judgmental analysis, is that the exercise that you were describing in broad terms a few minutes ago?
Yes. On the balance between what it does, if it's life-saving, you're prepared to accept a higher degree of adverse reactions.
And then this continues. It's disappointing, though, that 48% of applications should provide deficient preclinical safety data concerning general toxicity testing, mutagenicity screening, and carcinogenicity studies. Although in some instances these involve differences in data interpretation between the committee and secretariat and the company's experts, the majority of instances were about inadequacies in both the design and conduct of studies. Now, that seems a fairly high proportion of applications having deficient preclinical safety data, mostly due to inadequate or inadequacies in design and conduct of studies. Was that a pattern which you saw generally throughout the 1980s, or was this something unexpected at this point in time?
I can't recall, I'm afraid.
Now, I've been asking you in general terms about licensing applications, so first-time applications. What about an application for variation of a license? Would the approach be any different or less stringent if what was being sought was a variation of the license?
Well, it would depend on what was being requested, but I mean, if it was an extension to the indications, then we would look to see what the evidence was, that it was efficacious, beneficial. But of course, it might mean a different dose or a different duration of treatment. So we would also have to look at whether the original application contained all that was necessary in terms of the new indications that were being proposed.
I want to take you back to the document that we first looked at this morning, MHRA 00047773. We start with the first page, just to remind us what the document is. So this was the July 1977 leaflet on the control of medicines in the United Kingdom. If we go to page 17, I want to ask you about a paragraph that we didn't look at earlier. So it's the top half of the page, headed Dissemination of Information. Paragraph 50, communication with the professions is an important part of the committee's work, both to warn about adverse effects and to encourage cooperation by providing feedback of information. The following are the chief ways in which this is carried out. And then we have 6 forms of dissemination of information. A, leaflets in the adverse reaction series are issued to all doctors, dentists and pharmacists when it's necessary to give urgent warnings about dangerous adverse reactions. B, less urgent warnings may be covered by a Dear Doctor letter from the chairman of the committee. C, a series of leaflets, Current Problems, has been introduced to bring to the attention of the professions information on possible early warnings of problems. D, a regular printout of the Register of Adverse Reactions is provided from medical libraries and postgraduate centres. E, any doctor or dentist submitting a report receives a copy of the relevant part of the printout from the Register of Adverse Reactions together with notes on its interpretation. And then F, articles resulting from investigations made by the committee are published in the medical journals. Now, there are obviously a range there of different ways in which information could be provided to the professions. I just wanted to ask you about the first 3. The leaflets in the adverse reaction series, described there as issued when necessary to give urgent warnings about dangerous adverse reactions. How quickly could an adverse reaction leaflet be produced? Can you recall?
I'm afraid I don't recall these adverse reaction series. I remember the Dear Doctor letters and I remember Current Problems vividly, but these adverse reactions series are new to me. I don't think when I was involved we produced them anymore.
If we then look at B, the Dear Doctor letter, that
Yes.
was, is it right to understand, that was something done on an ad hoc basis. It wasn't a regular publication, but as and when the CSM...
No, it was done when it was necessary.
And that would be sent to every doctor, dentist and pharmacist, if appropriate.
Well, I think it was only doctors.
And then the Current Problems leaflets, was that a regular publication, as far as you can recall?
Yes, I think it was produced 3 or 4 times a year.
If we look at the 1990 annual report that we looked at before, I think we can get some idea of the Current Problems publications remit, WITN 6406003. So this is the CSM's 1990 annual report. We looked at different parts of this earlier. If we go to page 6, we have the heading 6.2, communications with doctors, dentists and pharmacists on matters of drug safety. And then it says, so this is for 1990, 3 editions of Current Problems. The committee's drug safety information bulletin for doctors, dentists and pharmacists were issued as follows. And then we can see there's Current Problems 28, May 1990, articles on a range of different products. And then point 7 is adverse reactions, what to report. Current Problems 29, issued in August 1990, again has articles on a range of different products. And it looks from point 8 as though it has a reminder about the yellow card scheme. And then if we go to the top of the next page, Current Problems 30, December 1990, contained articles on, and then the first is about fatalities following a particular product, and then again a range of other a range of other products that they're dealt with. So it looks from this as though Current Problems wasn't limited in any particular sense. You could include within it such information, advice, warnings as you thought appropriate. Is that correct?
That's right, yes.
And if we go to WITN 6406005, this is a document, I don't think we have the precise date, but it looks like it's from 1993, from the top right-hand corner. It's from the Subcommittee on Pharmacovigilance, and it deals expressly with the Current Problems Bulletin. If we look at paragraphs 1 and 2, please. So current problems bulletins provide information on the adverse effects of medicines and are distributed to doctors, dentists, coroners and pharmacists 3 to 4 times per year. And then paragraph 2 explains under the heading background, current problems bulletins published since 1975 are distributed to all doctors, dentists, coroners and pharmacists in the UK about 3 to 4 times a year. In 1988, the findings of a survey of DH prescribing literature indicated that there was a need to improve the content and style of the current problems bulletins in order to increase their interest and impact. As a consequence, various changes have been introduced. Do you have any recollection of what had been identified as needing to be changed in the content and style of the bulletins?
No, I'm afraid I don't. No, I can't remember.
And then if we look at the bottom of the page, under the heading Nature of Articles, it says articles in the bulletin fulfil a number of functions and include the following. 1, preliminary information about suspected adverse drug reactions, mainly identified from spontaneous ADR reporting. This is used to stimulate reporting so that more information may be collected to clarify particular suspected ADRs. 2, articles on a series of reports characterising adverse reactions to a particular drug on the basis of which warnings and precautions regarding the use of the drug may be introduced or reinforced. 3, the findings of a comprehensive review of a particular drug's safety concern, giving specific new recommendations on the use of a medicine which reflect amendments to the data sheet, patient information leaflet or labelling. And then over the page, it's the last 3, top of the next page, last 3 points. There's in-focus articles which review the safety profiles of newly introduced medicines about 1 to 2 years post-marketing. These provide comparisons with drugs in the same therapeutic class when appropriate. 5, reminders of adverse reactions or precautions which should be well known but which may have been forgotten. And then 6, updates about particular diseases, symptoms, signs which may be drug-induced. And then it explains that the bulletin also includes reporting guidelines, carries posters twice a year listing newly introduced medicines, those labelled with the black triangle which are under intensive surveillance. Now, it looks from this, Sir Michael, as though the current bulletins, current problems bulletins could really cover anything that the CSM thought needed to be brought to the attention of doctors and pharmacists and dentists. Is that right?
That's right. Or if the staff of the Medicines Division or the Medicines Control Agency.
Were there any particular criteria for deciding whether to disseminate such information about a particular product?
Not that I recall, no.
Did you, if you were going to include information in a current problems bulletin, did you let the manufacturer of the product know in advance or give them any opportunity to say it shouldn't be included?
Not that I recall, no.
And then lastly, before we break, we can see that this is a publication directed at doctors, dentists, coroners and pharmacists. Were there any publications that were directed at the public produced by the CSM?
No, not in those days, no. Not as I'm aware of. But, I mean, the only thing is that the public did get to hear about Dear Doctor letters because they tended to get leaked to the press.
Okay. And then I'll pick that up, Sir Michael, after the break, if I may, with some issues relating to Dear Doctor letters. So I note the time, perhaps the suitable moment for our first break.
Yes. Well, we'll take a break now until 11:45. 11:45. Now, you're giving evidence. I don't know if there's anyone there with you that you might talk to, but you may not, while you're giving evidence at any break, say anything at all about the evidence which you have given or any evidence that you think you may yet be asked to give. You can talk about anything else you like, but not that.
No, the only person here is the technician who's set the kit up for...
Yes, and you're at home, I think, aren't you?
I'm at home, yes.
Well, we'll take a break till 11:45.
Thank you, sir.
Thank you.